So many questions, so little time, as is always the case. I think there's a bit of a contradiction really in the statement of the Commission and the reality on the ground. I mean, 4 visits in almost 4 years. You admit yourselves that despite those visits showing up non-compliance in a whole number of areas, despite extensive publicly available corroborated evidence of pushbacks and systematic violations of human rights on the border of Croatia and Bosnia-Herzegovina, that you still seem to be saying, well, sure, look at lads, go ahead, you can come and join the party. And there is a real contradiction between this. What it seems to be saying is that as long as member states seal the European Union's external borders, well, then you can get into Schengen, regardless of the fact, and the Commission acknowledges the fact, that the human rights of asylum seekers are being violated and that the use of force at that border is excessive. You've acknowledged that by saying that these remain a challenge. So on the one hand, we have a detailed criteria outlined in relation to border control, all very good and grand, but then in human rights, it's all real woolly. You talk about a monitoring mechanism, but how is that functioning? Who's involved in it? What's the time frame for it? What Commission services are involved? How is the European Parliament going to be informed of those developments? Like, how can the Commission give the green light in the absence of that? Because what you seem to be saying is that some legal obligations are more important than others. Do you not accept that it's actually a legal requirement of Schengen that all criteria must be implemented, all legal criteria, and that means respect for fundamental rights, which is not happening in this instance. And I think specifically we need answers to the questions about what evidence was taken into consideration when assessing the compliance of Croatia with Article 4 of the Schengen Borders Code on Fundamental Rights. We need answers to whether the Commission will prepare specific recommendations on fundamental rights compliance that the Croatian government will need to respond to as part of the action plan to be adopted by the Council. How will next year's assessment of the Schengen evaluation and monitoring mechanism seek to address the inadequacies that we all know are there? And why should we allow it to proceed ahead of these criteria being met? It is a two-tier legal acknowledgement of rights, which is actually unlawful in and of itself. And I really think we need these issues answered and addressed before this process can go any further.
I would like to start with the fundamental rights, because in fact this was one of the main issues which has been brought up. And here in particular the issue of the pushbacks. So in preparing its assessment, the Commission examined how Croatia implements the commitments it took up upon EU accession as regards to fundamental rights. And the Commission can confirms in fact in its communication that Croatia continues to make progress in improving the protection of fundamental rights. Specific allegations made with regard to the treatment of asylum seekers should be subject to credible investigations by the Croatian authorities according to national law, and we, the Commission, therefore expect Croatia to follow up promptly on these allegations and to keep the Commission informed. And the Commission will continue to closely monitor the situation. Also to be kept in mind that once a Council decision on Croatia's full accession to the Schengen area had been issued, the Commission would also have the possibility to carry out unannounced Schengen evaluation visits. For the time being, however, unfortunately, we can only make announced visits, which of course takes away, as you have mentioned, a bit the surprise element when coming to the external border. So such unannounced visits, in fact, if possible, once the internal border controls would have been lifted, would definitely increase the monitoring possibilities of the Commission.
Mrs. Dalli, 1 minute, please.
Yeah, well, just as we have time, and I don't think there was enough detail in the answer, to be honest with you, because I'd like more information on when the monitoring mechanism was set up and how does it work. I mean, you're talking about the UNHCR and the Croatian law society being involved in this, but is there a central monitoring body How does it work? Are you just giving money out to various groups? I mean, for example, on the training, how many police officers have been trained? How do you know that they've been trained? Who has overseen that work? Because you see, the problem here is that the Commission has recognised that there is a problem with the protection of human rights. That legal criteria has not yet been fulfilled. And yet you're saying that this participation of Croatia in Schengen should proceed. Now, that's unlawful as far as I'm concerned, because all legal requirements are equal, and you've acknowledged that the fundamental human rights legal requirements haven't been fulfilled. So I'd really like some more information on how the monitoring mechanism was set up, including dates and times, or was it when you gave them the money, or what's the story there?
Well, the project itself, the emergency assistance project on the monitoring mechanism started on the 1st of September 2018. It's running for 14 months until 31st of October 2019. So practically it has already, but 1 month of extension is just being processed at the moment. So it's not fully over yet. And the monitoring mechanism itself started in April 2019 and will close with a round table on the results. The round table, just as the project has been prolonged, is still to be seen when exactly this is taking place.